Money spent by the government on court cases in a decade, 400 crore. The amount incurred on the litigations has gone up since 2014-15. Bodies of hostages to be swapped for prisoners. Hamas said it would exchange the bodies of Israeli hostages for more than 600 Palestinian prisoners on Thursday. Number of civil services jobs to be slashed in Hong Kong by 2027. 10,000. Hong Kong's finance chief unveiled a belt-tightening budget on Wednesday that aimed to end the city's string on record high deficits by 2028. The US government spending in the first month under Trump $710 billion. The US government spent more during President Donald Trump's first month in office than it did during the same period an year ago. Proposed boost in California's film and TV tax credits. Why are persons with disabilities worried about the DPDP rules? Why are persons with disabilities concerned about certain provisions in the draft rules of the Digital Personal Data Protection Act 2023? Who are data fiduciaries and data principals? How are legal guardians defined under the draft rules? With the Ministry of Electronics and Information Technology looking to wrap up public consultations on the draft rules for the Digital Personal Data Protection Act by March 5, disability rights activists are trying to get a keynote provision of the Act amended or dropped, pointing out that it infantilizes persons with disabilities, negates their decision-making capabilities, and comes from a misunderstood notion of how guardianship works for PWDs. Section 9, Clause 1, in clubbing children with PWDs, has mandated that even in cases of adult persons with disabilities who have legal guardians, consent for use of any personal data must be obtained from the guardian concerned. While government officials have said the draft rules have tried to address the issue by limiting the number of disabilities, the provision would apply to activists and experts maintain that there remain significant challenges in its implementation. The Union government has said that it brought the DPDP Act 23 to govern the processing of digital personal data in a way that recognizes both the right of individuals to protect their personal data and the need to process such personal data for lawful purposes and for matters connected therewith or incidental thereto. Section 9, Clause 1 of the Act says the data fiduciary shall, before processing of any personal data of a child or a person with disability who has a lawful guardian, obtain verifiable consent of the parent or such child of the lawful guardian as the case may be, in such manner as may be prescribed. The Act's language defines data fiduciaries as those parties processing the personal data and data principals as users whose being data is collected. But in section 2, clause J, subclause 2 for the PWDs, the Act has included lawful guardian within the meaning of data principles. In the draft rules notified by MITI on January 3 this year, the government has proceeded to send out rules that will govern the Act. In these rules, Rule 10 deals with the governing of Section 9, Clause 1 of the Act. Rule 10.2 says data fiduciary, while obtaining verifiable consent from an individual, identifying herself as the lawful guardian of a person with disability, shall observe due diligence to verify that such guardian is appointed by a court of law, a designated authority, or a local level committee. Under the law applicable to guardianship, in the next subsection, the rules provide considering guardianship under the Rights of Persons with Disabilities Act and the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities Act 1999. It also goes to define persons with disabilities for whom the consent clause of Section 9, Clause 1 would apply to as individual who has long-term physical, mental, intellectual, or sensory impairment, which in interaction with barriers hinders her full or effective participation in society. equally with others and who, despite being provided adequate and appropriate support, is unable to take legally binding decisions. And an individual who is suffering from any of the conditions related to autism, cerebral palsy, mental retardation, or a combination of any two or more of such conditions, and includes an individual suffering from severe multiple disability. But while the rule on how to take the consent of the parents of children contains detailed explanations in the form of illustrations that highlight different scenarios and how the consent procedure would work in each, there is no similar illustration presented for the subsection that deals with taking consent of the guardian of a person with disability. This has led to disability rights activists and experts alike to question how the consent clause would apply to PWDs, details of procedures for different disabilities, and degrees of severity, and whether it would apply uniformly to guardians appointed under different laws. The legal guardianship for PWDs, while not mandatory, is governed by the two laws in India, the RPWD Act 2016 and National NT Act 1999, both of which mandate different roles for the guardians appointed under it. For adult PWDs, the NT Act's guardianship clauses apply to people who are diagnosed with conditions related to autism, cerebral palsy, intellectual disability, or any combined occurrence of two or more of these conditions. It provides for full guardianship of the PWD. In contrast, the RPWD's guardianship clauses apply to people experiencing long-term physical, mental, intellectual, or sensory impairments, which, when interacting with various barriers, hinders their full or effective participation in society on an equal basis with others. This provides for a limited guardianship, which allows for support in making specific legal decisions when an individual capacity is deemed insufficient. When the NT Act goes against the principles of the United Nations Conventions on the Rights of Persons with Disabilities by making decision-making capacity a metric for guardianship while adequately defining it, the RPWD Act, drafted to keep up with the UNCRPD, frames guardianship as support to PWDs in exercising their own decision-making rights. A small survey among 91 PWDs by policy think tank PACTA and Saksham Disability has shown that 27% of them had legal guardians. Among those respondents who knew their law and guardianship was governed by most said theirs were under RPWD Act's provision for limited guardianship. But despite this, the practicalities of guardianship are different as reported by Saksham and PACTA. Adding that most of the PWDs with guardians maintained that their legal guardians ends up managing all their affairs. The report released last month noted that while Act and draft rules are sound in theory, if the guardianship is under RPWD Act, the realities of how this guardianship works would mean a guardian is likely to deprive the autonomy and personhood of the individual. On the other hand, in cases guardians appointed under NT Act, this would be in direct conflict with the autonomy of persons with disabilities under UNCRPD. The report noted that a plain reading of Section 9, Clause 1 of the DPDP Act appears to presume that just because persons with disabilities might have a legal guardian, this in itself would be indicative of their inability to take decisions in the digital sphere. In addition, it said the law does not consider intersectionality of gender and disability. It cites a situation where a person with disability, women, women may not be able to buy sanitary napkins from an online platform because it may now require their guardian's consent for them to be able to access the platform itself. Nipun Malhotra of the Nipman Foundation, who is leading efforts to lobby the government on these provisions, has said that Section 9, Clause 1 of the DPDP Act itself has caused enough chaos on how it would apply to whom and under what circumstances. As for the government's attempts to address the issues with the law by limiting the definition of PWDs in the draft rules, Mr. Malhotra told The Hindu instead of simplifying how it would apply, the definitions have further complicated the issue. Citing one example of the definition, he explained that physical impairment has been included, but there is no provision for people with just physical disability to have legal guardians. This will only confuse people more. Given the way that consent clause has been structured for persons with disabilities in the DPDP Act and draft rules, some of the principal concerns that have emerged include those of what legal obligations would the guardian of the persons with disabilities face, how the consent clause can be implemented in cases where guardianship law is in dissonance with the UNCRPD, and whether the legal guardian can opt out of consenting on behalf of the user with respect to specific platforms. Another issue highlighting by the Saksham in their report has been that of concerns among PWDs about what the fate of their personal data will be. For instance, the rights body has posited that to comply with Section 9 Clause 1 of the Act, any data fiduciary would have to ask at least two questions: whether the user has a disability, whether the user had a legal guardian. In cases where the answer to the first question is yes, but the second is not, the platform will still have data on the person's disability with no purpose to process it. Further, Saksham has questioned that if the definition of data principle includes the legal guardian of a PWD, would then mean that they must take on full legal responsibility and face penal consequences under the Act. It has been argued that if this is the case, the legal guardian may at times be acting in their own interest instead of the PWD they are caring for. Moreover, experts working on the disability sector have pointed out that beyond all of this, the primary barrier to PWD's digital rights remain remains that of inaccessible platforms and applications. According to 2023 accessibility evaluations conducted by the Vidhi Center of Legal Policy of 10 most used apps, platforms like Paytm, Swiggy, Zomato, and Flipkart have low accessibility scores. So it has been argued that in this case, legal guardian may at times be acting in their own interest instead of PWD they are caring for. Moreover, experts working in the disability sector have pointed out that beyond all of this, the barrier to PWD's digital rights remains that of inaccessible platforms and applications. According to 2023 accessibility evaluation conducted by Vidhi Center for Legal Policy, of the 10 most used apps, platforms like Paytm, Swiggy, Zomato, and Flipkart have low accessibility scores. Section 9, Clause 1, clubbing children with PWDs has mandated that even in cases of adult persons with disabilities who have legal guardians, consent for use of any personal data must be obtained from the guardian concerned. The legal guardianship for PWDs, while not mandatory, is governed by two laws: RPWD Act 2016 and the NT Act 1999, both of which mandate different roles under the guardians appointed under adult PWDs. A small survey among 91 persons with disabilities by policy think tank PACTA and Saksham Disabilities has shown that about 27.4% of them have legal guardians. Among those respondents who knew which law their guardianship was governed by, most said theirs were under the RPWD Act's provision for limited guardianship. Why the south of India is no longer impervious to the saffron march? A case study of Kerala shows that last frontier of Hindutva is being breached in the south. A new book edited by Nisim Manna Thukaram examines the rise of Hindutva in relation to state's history, caste, culture, post-truth ideology, gender politics in the Indian national space. Trajectories of North and South Indian history have moved at different levels. Unlike India, where history is often a recollection of invasions, wars, massacres, and destruction, the South has been more about accommodation. The Arabs settled permanently in the coastal regions of the West and the South from about 8th and 9th centuries. The dichotomy continues to this day. The Arabs settled permanently in the coastal regions of the western and south from about 8th and 9th centuries. They were welcomed, given the land for trading stations, left free to practice their religion, and had been conventional with Christians earlier in South India. Among the most interesting aspects of Arab settlements among the West Coast is that in each group adopted some of the customary law and even some forms of worship from the local community with whom they had the closest contact. It is in stark contrast to what happened in North India with the invasion of Sindh and Muhammad bin Qasim in 712 CE and later the raids of Mahmud Ghazni. Each of among the more interesting aspect of Arab settlements along the west coast is that each group adopted some of the customary law and even some forms of worship from the local community with whom they had the closest contact. The dichotomy continues to this day. For instance, while North India has been awash with the resurgent Hindutva since the time of Ayodhya dispute and the consequent othering of fellow citizens of other faiths, large tracts of South India have consistently resisted the march of Hindutva forces. But the limited electoral success does not necessarily mean the South is impervious to saffron march, arguing the Hindutva is a real force which needs to be contended with in theoretical and empirical terms. Journalist and writer Nissim Manna Thukaren and several others examine the rise of Hindu nationalism in Kerala, Hindu nationalism in South India. Hindu nationalism appears more confident, proud, brazen, and belligerent than ever before. Quoting Edward Anderson and Longkumar, but the expansion is not just electoral, it is also socio-cultural, he says. That is why, despite the lack of comparable electoral success, it is vital to map the tectonic changes that are happening to discursive level across India. An electoral analysis of the NDA and the BJP shows that they increased the vote share from 6.3% to 10.83% and further 15% in 2019. While increase in votes have not been enough to win any seats, the changes are very important considering the Hindu population is around 55% in the state. In Telangana, BJP won 4 parliamentary seats in 2019. In the 23 assembly election, it increased its share from 6% to 13%. Its total votes from 14 lakh to 32 lakh and its seats from 1 to 8. Effectively, every seventh voter has voted for the BJP's narrative of Hindu nationalism. The most significant saffron gains have been Karnataka, where the BJP made an electoral breakthrough as early as 91, according to Manna, Manna Thukaren. South India as a whole cannot be generalized for these. For there are regional variations among states, such as significant advancement of Hindutva in Karnataka, but crucially, there are variations even within states. A socio-cultural change is taking hold, as Zefrelot points out in his essay. It happens through a couple of processes. Firstly, the denigration of secularism, religious figures wielding state powers, new laws targeting conversion, a ban on beef, Hinduization of street city names, rewriting of textbooks, etc., which give legitimacy to Hindu nationalism. And second, the previously covert but now visible forms of discrimination against religious minorities, While the rise of Hindutva politics has touched almost every part of the country, its roots go back all the way to the time of Jawaharlal Nehru. As Zafralot notes, Nehru fought against all forms of communalism, whether Hindu, Muslim, or Sikh, not against religion per se. He never intended to separate politics and religion. Nehru outlined his views on the subject in 1961 when he said, "We talk about secular state in India. It is perhaps not very easy to find a good word in Hindi for secular. Some people think it means something opposed to religion. That obviously is not correct. What it means is that state which honors all faiths equally and gives them equal opportunities. We are not all Hindus, but we are all Hindustani, from Kerala to Kashmir." In a bid to overturn what he called the era of stagnation of the Soviet Union, beginning from Leonid Brezhnev's term, Mikhail Gorbachev initiated a series of reforms that infused socialism with ideas from liberal economies, which was Gorbachev's initiative called. Soviet Union maintained camps throughout its territory, where both conventionally convicted criminals and political prisoners were interned and condemned to forced labor. The collective name of these camps was Russian acronym for Main Directorate of Correctional Labor Camps. Beyond official ranks assigned to members of the government apparatus of the Soviet Union, one way was to separate them by perceived competence. Those in lower ranks were called apparatchik, and those higher up, literally a system of names. A tendency towards openness and transparency away from restrictions on the flow of information. While Gorbachev popularized the term, it emerged during Moscow rally of the same notable expression of Soviet civil rights movement. Prior to the phenomena the Soviet Union maintained a strict system of censorship encompassing all media available at the time. X emerged in response after Stalin's era as a form of dissident activity which individuals would make copies of censored works by hand and pass them on. Over 70% farmers still use cash to sell their produce. The share of farmers using electronic payments for agricultural related transactions rose from 8% to 18% in 2024. More than 70% still rely on cash to sell their produce, shows the data survey published by RBI. This share increased slightly since the pre-COVID years, despite the pandemic boom. Data shows the significant number of farmers still rely on word of mouth from traders and fellow farmers to discover market price for the produce rather than using websites or apps. Chart shows the share of farmers, traders, and relators use modes of payments for agricultural transactions in 2019, 22, and 24. Chart 2 shows the share of farmers using sources. While the increase of electronic payments among farmers was gradual, it was much sharper among traders and retailers. The share of traders using electronic payments from agricultural transactions grew to 28 to 31%, and among retailers it grew to 22%. Chart 2 shows the share of farmers using various sources of information about market prices of produce. Close to 55% said that their source of information was traders. Chart 1 and 2 put together clearly show that in terms of business transactions of information management, a large section of farmers have remained insulated from digital practices. Chart 3 showed surveyed farmers reasoning for crop damage during the Rabi season. Given the significant impact of climate change on agriculture, weather forecasts are cited as the primary factor influencing farmers' crop sowing decisions. Nearly 90% farmers identified weather forecast as the major factor, followed by irrigation availability at a distant second. Chart 5 illustrates farmers' share in final retail price in the selected goods. Since the significant portion of wheat is procured by the government, farmers receive 67% of its retail selling price. Farmers selling lentils, masoor, and chana gram also get over 60% of the retail price. In contrast, the share is lowest for perishable goods, with farmers receiving only about 40% of the retail price for potatoes and retail price for potatoes, mangoes, and cauliflower. A message to district magistrate and the police. Recently, two first information reports were registered under Section 223 of the BNS in Indore for violating the district magistrate's prohibitory orders under the issued under Section 123 of 163 of Bharatiya Nagrik Suraksha Sanhita. These sections correspond to Section 188 of the Indian Penal Code and Section 144 of the Code of Criminal Procedure, respectively. In a bid to make Indore free of beggars, the district administration has issued prohibitory orders on January 25. One FIR was registered against a person who gave alms, and second was registered against a woman's beggar's son who had taken responsibility for preventing her from begging, but she was found begging anyway. However, well-meaning the intentions of the district administration to make city beggar-free, an FIR cannot be registered for violation of orders issued under 163 of the BNSS. District magistrate may issue an order under the section only in urgent cases of nuisance or apprehend danger when there is sufficient ground. Begging in public may cause annoyance or disturbance to public tranquility, but it cannot be considered as an urgent case of nuisance or apprehended danger. Even if such an order could be defended, FIR cannot be registered for violation. Section 215 of BNSS bars such action by the police. Section 205, Clause 1, Subclause A of the BNSS says, no court shall take cognizance of any offence punishable under Section 206 to 223, both inclusive but excluding Section 209 of the Bharatiya Nyaya Samhita, except on the complaint in writing. Supreme Court held that Section 195 of the CRPC is in fact a limitation on the undeterred powers of the judicial magistrate to take cognizance under Section 190, and he must undermine and determine whether the power taking cognizance has or has not been taken away. In C. Munir Appan versus others and others versus State of Tamil Nadu, Supreme Court held that provisions of Section 195 are mandatory and non-compliance would violate the prosecution. In State of UP versus Mata Bhik and others, Supreme Court held the object of this section is to protect persons from vexatiously prosecuted upon inadequate materials or insufficient grounds. The in Madras High Court in Jeevan Dham and others versus State and others held that a police officer cannot register an FIR for any offence falling under Section 172 or 188 of IPC. However, the court observed that a police officer can, by virtue of powers conferred under Section 41 of CRPC, will have the authority to take action when a cognizable offence under Section 188 of the IPC is committed. Even the principles laid down in Lalita Kumari versus Government of Uttar Pradesh and others will not apply to the registration of FIRs under Section 223 of the BNS. What is Section 188? These sections correspond to Section 188 of the IPC and 144 of the CRPC. District Magistrates Prohibitory Orders. The approach line of action for Indore Police will therefore be to close the cases and intimate the district magistrate accordingly. In case the district magistrate wishes to proceed further, he may approach the court in writing as required under Section 215 of the BNSS. Though the state government could either initiate the state amendment in the BNSS to loosen the fetters of the Section 215 Clause 1 BNSS or enact a local law making begging a cognizable offence, it would would not be advisable to convert a petty civil offense into a criminal one. This might deter people from giving alms, but punishing the receiver of alms will make the situation worse. Beggars need to be rehabilitated, not prosecuted. So that's all. See you in the next one. Concerns about ethanol blended petrol program refuse to die down in Andhra Pradesh, and saying water resources are depleting and emission for factories are polluting the air, water, and soil. 20% in petrol by 2030 to 2025 as the way to a greener future. Ethanol blended program was set to way of addressing multiple concerns of growing energy consumption, etc. As of 2024, the blended percentage was 15% in the country. To meet the required target of 20%, by 25-26, 100,000 crore liters of ethanol would be required. The center announced relaxations in application process of environmental clearance, etc. Andhra Pradesh, Maharashtra, Haryana, Punjab have the highest number of ethanol factories, contributing to a substantial portion of overall production capacity. Since 2024, there have been continuous protests in Gummal, Gandipalli, etc. villages against this program. All three villages are located near a river or canal, which is the source of drinking water. Failed to take action against a factory production ethanol since 2008 in these districts. Much of the confusion regarding how polluting an ethanol plant can be arises from the fact that environmental clearances do not mention emissions to begin with. All ethanol production plants or distilleries fall under the red category, which means they have the pollution score of 60 or more. Farmers also fear the water guzzling factories will leave them with no water for their crops. Their fears are not unfounded. The grain-based ethanol factory require 8 to 12 liters of water per liter of ethanol. Niti Aayog report states when petrol was blended with 20% of biofuel, carbon monoxide reduced by 30% in four-wheelers and 50% in two-wheelers. While this may be true, scientists and environmentalists ask of what use the EBP program is if the gains achieved are negated by the harmful chemicals released into the atmosphere. So that's all. See you in the next one.